So, of course, now, today, the PM is expected to address the nation. One of the issues that we're anticipating is with regards to what's going to happen with our local government representation. Because as it stands right now, the court has ruled, the Privy Council, so the final Court of Appeal has ruled that the extension should not have happened. So it's not necessarily saying that it's outright criminal, but we're in a no man's land. We're in a no man's land for our local government representation. We can't wait. I don't think anybody thinks we could wait until the end of the year to hold the elections, as was the expectation before the ruling. So what's the government going to do? To what extent? We don't know. We don't know what's going to happen as we wait. One could argue we've been waiting too long. But for more on this topic, and also to help us explain the ruling, we have with us former Minister of Finance, but more importantly today, she wears the hat of legal scholar, right? Because finance is not important today. Today it is the attorney at law, not former attorney at law, attorney at law, Karen Nurse-Scherer is with us. Good morning, Karen.
Thank you so much, Sean. I nearly said Keaton because I do miss Keaton when he's not here with us. Of course, you know I love having being here with you, but of course, three of us.
Keaton apologizes, folks. He is under the weather and isn't able to make it for talking point. He would have been on AM Prime earlier. And my apologies for not mentioning that earlier at the top of the show. But Karen, with regards to this situation now, as we are, well, I don't even know if there's a precedent for operating in this situation.
Okay, so I think the first thing before I go into the meat of the actual decision and what struck me, because I read it over several times, is particularly the majority position of the Privy Council. And if you look at the newspapers today, I believe at least two of them put as the headline this issue regarding local government elections and the expectation. Looking forward, it may not be the word, but wanting to find out how the Prime Minister intends to address this issue. And even the Law Association has come out and said, call the local government elections now, so that there has been a cry from persons who I think the public has regard and respect for, calling upon the Prime Minister to call the elections. Now, one of the things I just happened to have read, which I'm not going to put too much store on it, but you never know, is that they are busy trying to find a way around, because the bottom line, and that's the bottom line, as far as I could see, and I think most people would agree with that, was that they did not want the local government elections to be held this year, and it's politics. It comes down to politics, and the politics is that the ruling party, the government, which is the ruling party, had not been doing very well. And this is within recent periods. First, we have, most recently, the THA elections, where, they were, I don't think it's a hyperbole to say they got the licking of their lives. 14-1,
Almost
they could have
15-0.
Almost a zero. And our wee boy, as I know Tobagonians like that expression, I think everybody was astounded at the extent to which they were beaten. So that was a big wake-up call for the government, because all these things are kind of dress rehearsals for what is to come, which is the national elections, which has to be called within the next 2 years and few months. And then prior to that, which is more relevant to our discussion today, is the local government election that was last held, I think on December the 2nd or 3rd of 2019. And under that legislation, before its amendment, the term of office had always been, also under its previous legislation, for councillors and aldermen to serve a term of office of 3 years, after which they would demit office, and within, I think, a certain number of days, you had to call a new local government election. And what the issue here, of course, is that you can't not pay attention to these things. when it was at the High Court level, the judge at that time, they had asked for judicial review of the decision not to call the elections. And the judge at the time said, yes, it merits, yes, it is a strong point that qualifies, but I'm exercising my discretion and I'm not hearing it. So they went to the Court of Appeal. The Court of Appeal heard it and dismissed it, and dismissed the matter. So they went now to the Privy Council. Now, all lawyers knew from year one, introduction to legal system, the judicial hierarchy. We know you go up the scale, and when you reach to what is the Judicial Committee of the Privy Council, which is equivalent to what used to be called the House of Lords in England, now called the Supreme Court, that's where the buck stops. That's where the buck stops. And so what I had wanted to say regard to the judgment, what struck me very forcefully, is it is clear, I mean, it would be naive on our part, let's put it that way, for us to think that the Privy Council is as far away as they are in England. They would have read all the papers, all the documents and the newspapers. They would be apprised of the issues. And I am confident that they were not unaware that the impetus for wanting to extend the office of the aldermen and the councillors to an additional year was to put off the local government elections for an additional year. And that would have been a parliamentary, and even the Privy Council's majority said, even said the government taking away a right of electorate. So what I will say is this, that having read the judgment shown, they did agree, and I don't think that the appellant, Balgobin Mirage, pursued it, that it was not a constitutional matter because it was on national elections and there were no precise provisions in the Constitution dealing with local government.
Right.
So, and I think both parties did not pursue it. So the arguments came down to whether this issue of retrospectivity, which we don't want to go into much, except to say what the government wanted to argue is that the Act, by its wording, the sections that they included, the two sections that were included, that extended it from 3 to 4 years and thereby their term of office for another year, they wanted to say that it applied to the incumbents, the ones who were there already, so that they had another year in office, which is really being retrospective because you're taking the legislation and applying it to a situation before.
Without it actually saying so.
And what is said and what the majority said, that argument does not apply to statute. When you're dealing with statute, if a law is to have retrospective effect, it must be clear, it must be unequivocal that that is its intent, and that was not there. But that was not the real issue. It is clear to me, and that is a shame on us, and why I talk about executive overreach, which we're seeing many more examples, is the reasoning of the majority on that, Keaton. And that is because they did recognize that there were possibilities to interpret it in certain ways. They did not discount it completely, They did not. But what it was that made them think, it is the reasoning of depriving the electorate, whether at the national or local level, of their democratic right, which is consistent with a democratic republic. And if you doubt that, you just have to read the judgment, starting from about paragraph 31, of because they had to lay the groundwork first. From paragraph 31, you're picking it up? From paragraph 31, and you will see for yourself the extent to which the law lords took great exception to that. They said at paragraph 31, they talked first in paragraph 31 about representative democracy principles are appropriate in this case. Then in 31, you probably have it better written than I, because it's all in my handwriting sometimes, which I cannot even read. An essential character of a representative democracy, whether national or local, is that the representative is chosen by popular vote in a modern democracy as Trinidad and Tobago, all individuals have the right to participate in popular votes subject to certain qualifications. Then it said, it is an essential element of a democratic form of government, whether national, which is repeating that. That they said, and this was very, the language was very harsh. I think you would have it, and think about Gov't 35, which said that the rights conferred by a democratic system are not only individual rights enjoyed by each person entitled to vote. It is a right of all members of the relevant, well, that's what I can't make out. Must be the relevant, you have it there? Relevant what?
I don't have it, I don't have it.
Anyway, relevant community to be governed by representatives chosen democratically, whether or not in an individual right to vote, it has a right to exercise that right. But this is what I really wanted. This is what I wanted to go to. So 33 says, a democratic society will necessarily engage other rights and freedoms of expression, for example, but the election of representatives for a fixed or maximum period is the foundation on which it is built. And finally, the last one I'm going to use, it is inimical to a representative democracy that the representative is chosen by anyone other than the electorate. It is not for Parliament, still less the government, to choose the representative. If that was applied, if it is applied to the incumbents, that would have been chosen for another year, not by the electorate, but by the government, who brought those amendments into force, which while councillors and aldermen were still in office. So it is very, very clear to anyone who reads the judgment that what I think was the deciding and overwhelming decision for them was the fact that the government, they said it still less the government, they said the Parliament still less the government, to take away and exercise a right of the qualifying electorate to exercise their right to vote, which is consistent with a democratic republic as Trinidad and Tobago. So the criticism, and at the end of it, when they finally wound up on their speech, where they gave another argument and say, no, you're making too much fuss about this amendment. The amendment is really a little modest amendment. They were very terse in their response. It's far from a modest amendment. This is going to the very foundation of a democracy. That is the argument. So I can't see how the government can get around that. And this numbers game, I have to say, the Attorney General, Reggie Moore, well, I don't know if you know any longer.
When he basically said, well, yes, but you're referring to when he said, well, 3 disagreed.
Okay, so that's what I want to say.
But 7 agreed or
No.
Or 5
I want to say
agreed
this.
with me.
I have to say this. And Reggie Moore is a good friend of mine. He actually represented me for a while in my matter. I've known him from Caveville. But I have to say this, without fear or favor, it is demeaning to your office. It is demeaning to your office. It is nonsensical for you to come to the public as a titular head of the legal profession to play a numbers game. So what are you saying about the legal hierarchy? It is a nonsense.
Yes,
it is a nonsense.
That's a good way to put it, but I'll have to ask you to pause there.
Yes.
We'll stick up in and out. We'll come right back to that. Folks, we have to take a break. When we come back, we'll continue on this point specifically, but I also have some questions for Karen with regards to the fact that, but the Privy Council is the Privy Council and the appeal court here is the appeal court here. They're not the same things. Folks, more on that after this.